Yes, people hate them. People want them jailed. People think they should not even waste time being arraigned in court and witnesses called. They should be summarily be jailed. Those children cannot be forced to confess. They cannot be taken to prison. The CCTV footage will be given to the children and their advocates. The witnesses who will be testifying, if it's teachers, if it's the police, if it's the watchmen, if it is anybody, that evidence will be given to the children in advance for them to prepare. Those CCTV footage, if they are AI generated, if there are robots that have generated that, the defense will take them and subject them to proper analysis. I said this, those CCTV cameras were installed where the kids were sleeping. Under Article 31, the Bill of Rights, the right to privacy is protected. Was it violated? It was violated. Those kids are likely to go home scot-free. Let me tell you, the earliest that trial will take is 4 to 5 years. Welcome to Court Helicopter Explainer. This is about the trending story of Utumishi Academy. 7 of their pupils or students were arraigned today in court. The state took these minors to court and asked for 30 days. This is to enable them conclude investigations. This is provided for under Article 49(1)(g), which says an arrested person or child has the right at the first court appearance to be charged, they were not charged, or informed of the reason for the detention continuing. That is a provision under Article 49(1)(g). The detention started on Friday. It is continuing today. That is a constitutional provision. Arguments were made why the state wants to detain them for 30 days. The defense of the children argued why that is not proper. The learned magistrate has deferred the ruling to tomorrow at 2 p.m. when the court will make a determination, 1, whether to grant the 30 days, 2, or to reduce the number of days, or 3, to deny the application of the state and release the children on cash bail or on bond. Several questions were sent to us to provide the constitutional framework on the prosecution of those children. And we will bring it to you purely what is the constitutional law on those A7 students. Article 53 of the Constitution of Kenya. It is about the children. Article 53 says, every child has the following rights. What are the rights of those 8 kids who were taken to court today? Yes, people hate them. People want them jailed. People think they should not even waste time being arraigned in court and witnesses called. They should be summarily be jailed. That is the annoyance. We understand the pain. People are saying evidence is sufficient. But what is the Constitution talking about the 8 girls who were arraigned in court today? We'll deal with the 3 provisions of the Constitution. Article 53, Article 49, and Article 50 of the Constitution. The constitutional issues regarding those girls. Article 53. Every child has the right to a name and nationality from birth. That one has no issue. To free and compulsory basic education. So are those children going to be denied bail? And the Constitution says they must have free and compulsory basic education. Is secondary school considered a basic education? Yes. C, every child has a right to basic nutrition. So as they are in the cells, they must be given proper nutrition and health care. So if they are sick, they will be taken to hospital. D, every child has to be protected from abuse, neglect, harmful cultural practices, all forms of violence. So those 7 students should not be exposed to any form of violence. If they were beaten when they were in police cells, that is a ground for a serious challenge. 2, they are protected from any form of inhuman treatment. So the way those children are going to be handled, whether you think they are guilty, they must be provided with human treatment. 3, no inhuman punishment. So those children cannot be given strokes, they cannot be pinched, they cannot be caned. If the DCI used force on those children, they will be, the DCI will face the law. This is the Constitution of Kenya. E, every child is not to be detained except as a measure of last resort. So are those kids going to be detained in police custody or in prison custody? The law talks of that. That is the only last resort to be used. And when detained, if the court detains them, they must be held for the shortest appropriate period of time. That is the Constitution. They cannot be detained for long. Lastly, if they are detained, they must be detained separate from adults and in conditions that take account of the child's sex and age. At Gilgil police station, where the kids have been kept, they are supposed to be kept in what is called the CPU, the Child Protection Units. They are not supposed to be kept in a police cell with other women who have been arrested. If they were mixed together, the Constitution Article 53, 1F does not allow that. Then number 2, the child's best interests are of paramount importance in every matter concerning the child. The police, the school, the courts, the prosecution, the witnesses, the best interest of those 7 kids is of great importance. That is Article 53. Let us look at Article 49. The rights of arrested children or the rights of arrested persons. An arrested person has the following right. 1, to be informed promptly in a language that the person understands of the reasons for his arrest. So those 7 must have been told in the language they understand why they have been arrested. 2, they have a right to remain silent. Whether you show them the CCTV footage, they have a right to remain silent. 3, the consequences of not remaining silent to remain silent. C, they have a right to communicate with an advocate and other persons whose assistance is necessary. Those children have a right to be represented by an advocate of their own choice. So you cannot say they can't have an advocate. Many Kenyans were talking to us saying, Umar, will you be in the team to defend the kids? Why are advocates defending that kid? Every person has a right to have an advocate of their own choice. Then we have D. They have a right not to be compelled to make any confessions or admission that could be used in evidence against the person. We did that yesterday. Those children cannot be forced to confess. And if they are going to confess, it must be before a magistrate or before a police officer above the rank of a chief inspector of police. E. They are to be held separately from persons who are serving a sentence. They cannot be taken to prison. If they are taken to prison, they will be taken, remanded in the children remand centers. They are not going to go to Langata prison. Children are taken to remand centers. The remand centers are managed by the director of children's services, not by prison officers. F, to be brought before a court as soon as reasonable, possible, but not later than 24 hours after being arrested. And if the 24 hours ends outside ordinary court hours, or any day that is not an ordinary court day, the end of the next court day. These children were arrested on Friday. 24 hours was supposed to end on Sunday. Monday was a national holiday. That is why today they have been brought to court. H, to be released on bond or bail on reasonable conditions. So the children, even if the court wants to lock them in, they have a right to be released on bail or on bond on reasonable conditions. These are small children. They can't be told to pay cash bill of 50 million shillings. This one, advocates can argue their mother and father will stand a personal surety for those children because they have no money, they have no logbook, they have no property, they have no title. If there are compelling reasons, then they will not be released on bond. It is upon the state to provide compelling reasons. Number 2, a person shall not be remanded in custody for an offense if the offense is punishable by a fine only or by imprisonment for not more than 6 months. If the charges they'll be faced with, and that charge, the fine is an imprisonment for a fine, or if the worst they can get is an imprisonment for less than 6 months, they must be released from prison or from police custody. Article 50. What are the rights during the hearing? The rights of those 8 kids when this will be a hearing. 1. Every child has the right to have any dispute that can be resolved by the application of the law decided in a fair and public hearing before a court or, if appropriate, another independent and impartial tribunal or body. So these children, their case will be heard, but not in a public court. As children, the media will not be allowed to capture their faces. The media will not capture their names. The media will not capture the hearing. So, that is the position of the law. 2, every child has the right to a fair trial, which includes the following rights. 1, every of those 7 children is presumed innocent until the contrary is proved. Whether you have seen those CCTV footages, the law presumes those 7 kids to be innocent until a court of law decides that they are guilty. Only one person has the power to decide, and that is the judiciary. the police, the prosecutor, the public, the Minister for Interior cannot say those children are guilty. Even you, all those are allegations. Those children are presumed to be innocent until proved guilty. B, every child must be informed of the charge with sufficient detail to answer it. They must be given a charge sheet with express details for them to answer it. C, they must have adequate time and facilities to prepare for their defense. I know Kenyans are saying this trial should take a week, the kids to be jailed. The trial, let me tell you, the earliest that trial will take is 4 to 5 years, or it will go to 8 years. They must be given time to prepare their defense and to facilities to do that. D, they are supposed to be tried in a public trial before a court established under this constitution. They cannot be tried by a kangaroo court. All these people are talking on social media is kangaroo courts. The law talks of a court of law, a competent court of law created by the Constitution of Kenya. They will appear before a magistrate who has taken an oath. They'll appear before a judge who has taken an oath. E, to have the trial begin and conclude without unreasonable delay, so the trial will be expeditious. To have then F, to be present when being tried, unless the conduct of the child makes it impossible for the trial to proceed. Every day, these children will be in court. They must be brought to court. In a criminal trial, unlike a civil matter, the accused person must be in court every day. G, to choose and be represented by an advocate and to be informed of this right promptly. They must be represented by an advocate. H, to have an advocate assigned to the accused person by the state and at state expenses if substantial injustice would otherwise result, and to be informed of this right promptly. Under the Children's Act, every child is entitled to an advocate of the state for free when the offense is conflict with the law. So those parents, don't worry. If you cannot afford the services of an advocate, the government will give you advocates to represent your children for free. Those advocates appointed will be paid by the judiciary. That is the law. Those children cannot defend themselves without an advocate. Then we have I, to remain silent and not to testify during the proceedings. Those children, those kids can remain quiet. There's nothing about it. Under section 50I, they can keep quiet. J, to be informed in advance of the evidence the prosecution intends to rely on and to have reasonable access to that evidence. The CCTV footage will be given to the children and their advocates. The witnesses who will be testify, if it's teachers, if it's the police, if it's the watchmen, if it is anybody, that evidence will be given to the children in advance for them to prepare. Those CCTV footage, if they are AI generated, if they are robots that have generated that, the defense will take them and subject them to proper analysis. We want the state, the police are fond of doing that. This time, the defense will be hawk-eyed to ensure it is not AI-generated CCTV footages. K, to adduce and challenge evidence. They will challenge, cross-examine, they will also give their own evidence. To refuse to give self-incriminating evidence, they cannot be forced to do a confession. M, to have the assistance of an interpreter without payment if the accused person cannot understand the language used at the trial. The state must provide an interpreter for those children. They are Form 1s, Form 2s. They need an interpreter. And not to be convicted for an act or omission that at the time it was committed or omitted, it was not an offense in Kenya or a crime under international law. Or not to be tried for an offense in respect of an act of omission for which the accused persons has previously been acquitted. To the benefit of the least severe of the prescribed punishment for an offense. If the prescribed punishment for the offense has been changed between the time that the offense was committed and the time of sentencing. Q, if convicted, to appeal to or apply for review by a higher court as prescribed by law. So if they are convicted in Naivasha, they'll go to the high court. They can appeal or review. Then evidence obtained in a manner. 4, and this is very critical about the CCTVs. Any evidence obtained in a manner that violates any right or fundamental freedom in the Bill of Rights shall be excluded if the admission of that evidence could render the trial unfair or could otherwise be detrimental to the administration of justice. I said this. Those CCTV cameras were installed where the kids were sleeping. Under Article 31, the Bill of Rights, the right to privacy is protected. Was it violated? It was violated. Those kids are likely to go home scot-free. An accused person is charged with an offense other than an offense that the court may try by summary procedure, and a person who is convicted of a criminal offense may petition the High Court for a new trial if the person's appeal, if any, has been dismissed by the highest court to which the person is entitled to appeal, and if there is compelling reasons. 7. In the interest of justice, a court may allow an intermediary to assist a complainant or an accused person to communicate with the court. An intermediary for children can be teachers, can be a preacher, can be a priest, can be a religious person, can be an advocate, can be a nanny, can be somebody those children are going to rely on. They have got to be given an intermediary. Remember, these are children who are traumatized. 8. This article does not prevent the exclusion of the press or other members of the public from any proceedings if the exclusion is necessary in a free and democratic society to protect the witnesses or vulnerable persons, morality, public order, or national security. Article 58, the media will not be allowed to cover. Article 50, sub-article 8, the names of these children cannot be published. Article 50, sub-article 8, the name of the school cannot be published. Article 50, sub-article 8, the names of the parents cannot be published. Therefore, it will be conducted in camera. I have seen very many media paparazzis posting photos of the children. You will be arrested and you'll be charged. Those kids are protected under Article 50, sub-article 8. So, what is the intent of this matter? We have provided from Court Helicopter the constitutional rights of the 7 suspects. Those children, remember, they are children in conflict with the law. This is the Supreme Court. This is the supreme law of the country, and that is the Constitution of Kenya. Any violation of these provisions by the police, by the prosecutor, by the courts, the defense will be pointed. We wish justice, but also we also pass our condolences for the children, the 16 children who passed on in a very grisly manner. Wakili Dan Senomari, always a pleasure to bring it to you.